Okay, good morning, everyone. You beautiful, beautiful New Zealanders, not Aotearoaites. This morning, I'm going to talk more about the article that was published by Muriel Newman called Mana or Money, which looked at the corruption in New Zealand businesses with iwi interference in those businesses. And we're coming to the end of this series. I've done a series of about 6 videos on this. We're at the stage where we're talking about the beaches of New Zealand, the coastline of New Zealand being given to iwi. Most people don't even know this is happening. And let's pick it up right here. So I'm going to use just a highlighter to get us right. As you will be aware, the NZCPR, that's New Zealand Centre for Political Research, strongly believes the foreshore and seabed is part of our common heritage and should be owned by the Crown on behalf of all New Zealanders. Now, we all believe that. And so we're all in on that with Muriel about that. Accordingly, says Muriel, we campaigned against the introduction of MACA. Now, MACA stands for the Marine and Coastal Act, then opposed by the first High Court case. Accordingly, we campaigned against the introduction of MACA, then opposed the first High Court case Edwards in the public interest. But instead of deciding against the claimants, the judge, that's Justice Churchman, his name is, the judge here, and I'll show you a picture of him, he elevated tikanga above stringent Maori property rights that had been designed to rule out opportunistic applications. Now, tikanga is just Maori religion. It's Maori philosophy, Maori religion. And it's unbelievable that New Zealand would start to make tikanga law. L-A-W. In other words, Maori are getting to, iwi are getting to determine the laws of New Zealand. Now this opens the door to massive corruption, because who are the ones who can interpret the law and say what the law means? Answer, Maori. So the corruption levels are going to go through the roof if we keep doing this. And Judge Churchman did it. That's what he actually did. In doing so, in making tikanga law, he opened the floodgates for most claims to succeed. Now, I'm just going to go through something with you here on my laptop to look at how this actually happened. This is the New Zealand Law Association here, and it says here the factual findings for the coastal marine title. How did Justice Churchman come to this decision? Well, this tells you a little bit about it. 2 pukenga, that's experts, were appointed to help the High Court make the factual findings about tikanga. The groups which hold the application area in accordance with tikanga, and the entities which comprise each applicant group. The pukenga, that's the Maori experts, wrote a report setting out answers to these questions. So there were some questions put forward, and the judge had to, he basically appointed 2 pukenga. Can you believe this? Experts, so-called Maori experts, were appointed to help the High Court. Now, that is like asking the mongrel mob to investigate what's going on in the mongrel mob. It is a vicious circle of inquiry, and it should never have happened. Down here a bit further, it says, Churchman relied heavily on the pukenga report when making factual findings that led to the orders being granted. An applicant, that's a Maori applicant wanting this part of the coastline, needs only to satisfy the court that it holds the area in accordance with tikanga, and its use and occupation of the area has been continuous since 1840. So this is a complete scam. And if you read this report, it just makes you more and more angry, because let's go back to Muriel's article now, because what actually happened was that this Judge Churchman, who needs to be instantly sacked from any kind of legal responsibilities or legal jobs in the legal field, he elevated tikanga above the law, Maori religion, Maori philosophy, in order to make his decisions. I couldn't make this up, but it's actually happened. And he gave Maori blocks of the coast based on the opinions of these experts. So you've got Maori experts, and you know this, I know that Maori collude. The experts are all relatives of those who are making the claims. So if you get a report from a so-called Maori expert and all your relatives are in the area that's being claimed, what's going to happen? They're going to write a report that favours your own family. It's insider trading. It's a conflict of interest, but Judge Churchman didn't even worry about that. Can you believe it? He didn't. So let's click on the hyperlink here. It says, the judge elevated tikanga above stringent property rights tests that had been designed to rule out opportunity applications. So let's just have a look at where this leads to. And it's a New Zealand Herald article, and it's dated the 2010. So you can see how this happens. Look, this is how things move, and this is how things change. Starts off with a little act, 2010, called the Seabed MACA, the Marine and Coastal Act. And it says here, Attorney General Chris Finlayson believed that 2,000 kilometres of New Zealand's coastline will eventually be covered by customary iwi title. Now we know that it's going to be, he starts off with a little tiny thing, and then what happens is, he says, oh, it's going to be 2,000 kilometres out of 20,000 kilometres, so 10%, there we go. But what happens between 2010 and 2023 is that the Labour government gets in 2017, and they appoint activist judges. They fiddle with all the legislation, which opens the door to Maori claiming the entire coastline. And we've now got 600 claims at $485,000 each, paid for by the taxpayer, going through our courts. All the legal fees of the claimants are paid for by us, by me, by you. We're, like I said yesterday in my video, we are literally paying for Maori to take over our country. So let's just read a bit more of this. Attorney General Chris Finlayson believes that 2,000 kilometres of New Zealand's coastline will eventually be covered by customary title. Well, it's now 2024, and he's completely wrong, because the whole coast is about to go up. Why? Because a judge interpreted the law differently and ruled in favour of lowering the bar right down to the ground so absolutely everybody can claim, and suddenly you got 600 claims. What's the lesson? You never even open the door. This legislation, this act, the Marine and Coastal Act, should never have been passed in 2010. The government should have put its foot down. That's John Key and Chris Finlayson, and said, no, the coastline belongs to all New Zealanders. Like I said, New Zealand's coastline is about 20,000 kilometres, so Finlayson's guesstimate, as he put it, would be about 10%. Well, he's completely, absolutely wrong. Maori Party MP Turuot Flavel said on TV3 The Nation on Saturday that Hauraki iwi would be certain to put in claims for the Coromandel. They've done that. National reached agreement with the Maori Party and the Iwi Leaders Group a week ago to repeal the Foreshore and Seabed Act and restore the right of iwi to test customary title. So that was John Key. He was an absolute disaster, and with Finlayson. Those that are successful will become the legal owners, but the law will guarantee public access and it will be inalienable, unable to be sold. Now, this is a big point. This is what happens, is they say these things in the original act. That is MACA 2010. They say, oh, we'll guarantee public access and the land can't be sold. But then what happens is a radical left-wing marification government gets in a bit later, and they change that. They amend the law. They amend it. They make an amendment. And suddenly, public access has been stopped. And what happens then? You have tolls at beaches. You have people at boat ramps, Maori at boat ramps, charging for boats to be launched into their ocean. You have people wanting to go to the beach on Sundays and Saturdays and holidays. What's going to happen? You'll pay an iwi toll to go onto their beach. This is how things by increment change over time until you lose everything. This was 2010. And look how it's all changed for the worse. Honi Harawira, speaking on New Zealand's TV Muriel, yesterday's show, that's a television show called Muriel, yesterday left open the possibility of leaving his party on the issue because on the issue of MACA, Marine and Coastal Act, he was going to leave the party because they didn't go far enough. What did he mean? The deal had fallen short of replacing Crown ownership with Maori title. See that? That's where they want to go, right out of the mouth of Honi Harawira. He said, "We're not happy to just. We're not happy just to have the coastal area Maori given customary rights. We actually want to own it, the beaches and the ocean. We want to be the owners of it." So right there, it shows you what the goal of Maori is. It's not just the beaches, it's the whole of the country. They want to own New Zealand. And they are gunning for it. And little by little, increment by increment, they are achieving their goals. And the reason they're doing this is because of MPs in Wellington, of both parties that are weak and foolish, who are appeasing Maori at every turn, and giving in to them. And all of us, the rest of New Zealand, are going to suffer. That's enough today. I feel as though I'm getting wound up again.